Coming to the local practice seminar. Before I forget, in Salon B, the next hour, preparing to retire is not going to happen. Looks like Ted Wagner is not going to make it today. Amy has his slides or material will be posted online in case you want them. Please remember to fill out and turn in your certificate to get your CLE credits. The Wi-Fi network is Hilton Honors, and you've got a, I think, certificate for the day or something like that, and it's 1981. So today we are fortunate enough to have the tallest member of the Bar Association here with us and an expert in the debt collection area. And today it is the Fair Debt Collection Practices Act, or how he likes to title it, How to Collect Debts Without Making People Cry or File Lawsuits. Here is Brooks Granger.
That may be the nicest thing you've ever said. Good morning. The alternative title to this was How to Collect a Debt Without Getting Punched in the Face, but my staff thought that that was maybe too violent in today's world. The Fair Debt Collection Practices Act is a federal regulation regulating what are called third-party debt collectors. So for those of you attorneys in the room who collect your own debt, your own fees owed to you, you are not covered by this act. If you're collecting debt for a client or some other entity, you are very likely covered by the act. The reason behind it was prior to the act, the debt collection space was the Wild West. People were making threats, oh, I'm going to have you arrested if you don't pay this debt. We're going to take your kids away from you, all kinds of crazy stuff that was not supported by the law. So Congress, in its infinite wisdom, passed a law regulating the space. So there are a bunch of technical provisions that you have to comply with, or things out of the gate. For example, you have to send an initial communication to the debtor. Right out of the box, you have to send what's called the initial validation letter, or the IVN. That is what the CFPB, the Consumer Financial Protection Bureau, has called it. I don't know why it's an initial validation letter, because there is no subsequent validation letter. It has specific requirements of what have to be in the letter, which you can see in the materials, the amount of the debt, the name of the current creditor, that you have 30 days to dispute, so on and so forth. That area was a large segment of litigation. The Fair Debt Collection Practices Act is a strict liability statute. So if you violate the statute unintentionally, you're doing everything you can to comply with it, you're still in violation and you can get sued. The statute provides for actual damages, $1,000 in statutory damages, and the kicker is attorney's fees. So you're paying the attorney's fees of the person you're trying to collect the debt from. Regulation F is the CFPB regulation that governs the debt collection space. One of the things they did, the only nice thing that I will say they did, is they have provided us a form letter for the initial validation notice. That has, I would love to say that's eliminated the litigation around the IVN, but it's only reduced it. When you get the information from your client, hey, we want to collect against this person, here's what the debt is, so on and so forth, Reg F has a bunch of requirements that you need to get from your client because they have to go in the letter. You have to have an itemization of the debt, the principal, interest, fees, and other charges, and payments from a date certain. The CFPB selected 5 dates that they can use because they would be dates, quote, reasonably understood by the consumer. The last date that your client sent a statement to the consumer, the charge-off date, the last payment date, the transaction date, or the judgment date. In our experience, financial institutions will always send you the charge-off date. That is the easiest one for them to do because typically there are no add-ons to the debt after the charge-off date. There might be payments, but usually no interest is accruing, no late fees, that kind of stuff. Our experience in the medical debt space has been we get the transaction date, the actual date of service that the person went to the hospital or saw the doctor. The letter also requires that you provide information about consumers' rights. They can request the original creditor. They can dispute the debt, and then contact information about how to get a payment plan if that's the route the person wants to go. A couple of pro tips. Reg F says the IVN form they have is not mandatory. Why would you use anything else other than the safe harbor letter? Use it, use it, use it. The letter itself, the form letter, does not have a date on it. It simply says, as of today, you owe X number of dollars. It doesn't say, as of November 9th. There has been litigation around that fact. The fact is that the safe harbor letter has no date in it. People are litigating saying not having the date is somehow deceptive. Date the letter. You're not going to get dinged for dating the letter. Within the past couple of days after I prepared my materials, the district court in Nevada came out saying that not having a date is not deceptive. And the reason for that is the statute says you have 30 days from the day you receive the letter to take action, not 30 days from the date the letter is generated. So it's irrelevant what day the letter was generated. The FDCPA was designed to prohibit harassment or abuse by debt collectors. What that means is probably different to all of us. There are some specific examples set forth in the statute. You can't use the threat of violence or criminal prosecution. You can't use obscene or profane language. There was one case pre-FDCPA that I remember where the collector told the woman who had the debt that if she couldn't pay it, she should, quote, strap a mattress to her back and hit the streets. So those are the kind of reasons why we have this act. You can't publish the person's name in the newspaper saying they refuse to pay the debt, causing the telephone to ring, and etc. Reg F also has a lot of information in this space that we'll get to in a minute. Specifically, one thing to know is you cannot call before 8 a.m. or after 9 p.m. unless you know calling outside of those times is convenient to the consumer. Maybe they've told you, hey, I work second shift, so call me, later at night or early in the morning or whatever that might be. Some of the litigation that we see revolves around cell phone numbers. I don't know about the rest of you, but most of us, our cell phone number is the area code that we had at the time we got the cell phone number, whether that's our current area code or not. Also, you go on vacation. So you go to Hawaii on vacation. Creditor calls you. It's not 8 a.m. in Hawaii. How do they know you're in Hawaii? So these are the kind of things that consumer attorneys will sue over. One way to avoid that, obviously, is to figure out, okay, it is after 8 a.m. but before 9 a.m. in every state in the union between X times in my time zone. So you limit where you're making calls. Frankly, most law firms are not going to be making outbound calls because by the time the file gets to us, it has been worked over by the client and the collection agency to the point that anybody that was going to pay off of a phone call has already done so. However, Reg F further limited the phone call space. They have the 777 rule. You cannot make more than 7 phone calls per week to the debtor. Getting their voicemail and leaving a message counts as calling the debtor. You cannot call within 7 days after having telephone communication with the debtor. No calls or telephone conversations at the place of employment after being told it's prohibited. So you can call the consumer at their place of employment But if they tell you, hey, I'm not allowed to get calls here, you have to stop. If the debtor refuses to pay or requests the call stop, you must wait at least 30 days before calling. If the debtor requests a call back, you must call them back at the time they requested. So again, I haven't seen litigation over this yet, but I anticipate litigation. The consumer says, call me back at 4 o'clock. You call them back at 4:05, 4:01, 3:59. You do not call them back at the time the consumer asked. My tip to my staff would be, if the consumer is asking you to call back and says, call me at 4 o'clock, say, is it okay if we call you back during the 4 o'clock hour? Make some sort of affirmative step to make sure it's not exactly at 4 o'clock. That way you will be have more time frame to get that done and not run afoul of the statute. As you can see, this is very highly technical. My recommendation, I spend at least 2 hours, if not more, per week working on compliance with the FDCPA, reading case law, listservs, you name it, we review it. So unless you're doing that on a regular basis, a 1 hour class is not going to give you everything you need to know about the FDCPA. One of the purposes of the FDCPA and the purpose of the IBN is to allow the consumer to say, wait a minute, I don't owe this debt. I think there's something going on here. That's a process called validation or verification. Interestingly, and I'll get it backwards, the title of the statute says verification, but the text of the statute says validation, or vice versa. So those terms are often used interchangeably. Regulation F has, of course, regulations about this. At the time you send the demand letter or the IBN, you essentially have to review account level documentation. You cannot just go off of your client saying, yes, John Doe owes me $200. Again, to comply with Reg F, you have got to get information regarding when the debt occurred, the particular charge-off date or whatever other date the client is using. You also have to get the name and address of the original creditor from your client. Client has to supply the date and amount of the last payment and explain how interest and fees were applied if included. For verification, pre-Reg F, the 7th Circuit basically stated, as long as you have anything in your file that substantiates the debt, you were good to go. You could literally write the consumer back and say, no, I looked at my file, you still owe the debt. That was the minimum requirement. We always send account level information. So if you're disputing, for example, a credit card, we're going to send you 6 months worth of credit card statements. If you're disputing a medical bill, we're going to send you something showing the date of service and the charges incurred. We obviously do not have the detailed bill because your medical history is really not any of our business unless we have to go down into those weeds. The key is once the verification is requested, you must stop all further activity until such time as you send the verification. Whether you send it out the same day or 6 months down the road does not matter as long as you stop all activity until you send that letter. We try to send it out usually within the same day, if not within the same week. 7th Circuit case law still applies. In the materials, I've cited the case Watson versus EOS from 2018. The purpose of verification is just a check on the collection agency, not the underlying creditor. It is sufficient to look in your file and determine that your creditor gave you the same name, address, and social security number as the person contacting you requesting verification. If that matches, you can just literally tell the person, yes, you owe the debt. No further action is needed. The next section, the FDCPA prohibits false or misleading representation. I call this the common sense or the no-duh section of the law. You can't lie to the consumer. We have a Rule 11 obligation, obviously, and a Rule of Professional Conduct obligation not to do that anyway. This section is probably more directed at collection agencies. You can't falsely represent character, amount, legal status. Again, that non-payment will result in arrest or imprisonment. That's a theme throughout the statute, so obviously you can tell from before the statute went into effect that was something credit agencies were doing a lot. You can't represent yourself as a credit bureau if you're not a credit bureau. The other thing we see in this space is collection agencies walking that fine line and using names that look like law firms or heavily implying that they're a law firm when they're not. That is obviously also not a good idea. For those of us, obviously, lawyers in the room, I always view it as one of two ways. Assume the call is recorded. Would you really want Judge Broden to hear that call? Number two, would you want your grandma to hear that call? If the answer is no, I don't want Judge Broden or my grandma to hear that call, you probably should have taken a different course of action. Do you want your client to hear that call? We represent a lot of large financial institutions and a lot of government entities that are very serious about their reputation. So you may find something that's close to the FDCPA line and it's in fact on the good side of it, and you're going to find your clients do not want you to go anywhere near that line. Again, the communication requirements, the statute sets that out. Reg F talks about it. If it is a communication directly with the consumer, you must give the mini Miranda. I printed that on the front of the document, or in the front of my materials. This communication is from a debt collector. This is an attempt to collect a debt, and any information obtained will be used for that purpose. My wife knows it's been a long day when I answer the home phone that way or my cell phone that way. It has happened. I probably say those words more than I say anything else other than yes, dear. So that is just in every message. It's on every piece of paper that goes out of our office. The Reg F talks about voicemails. You must include the business name and that the call is from a debt collector and a telephone number for the consumer to return the call. Prior to Reg F setting forth the safe harbor messaging that it has set forth, there was a tension whether you left a message that simply said, hey, this is Brooks from Kreiser & Associates, call me back at 574-272-1000, or whether you left a message that said, this is Brooks calling for Tom, this communication is from a debt collector, so on and so forth. The first message is arguably not giving them enough information that you're a debt collector. The second message, if you play that message back and you're the consumer, you play it back, it's oftentimes on speakerphone, your friends that are sitting around you have now heard that the person is a debt collector. So the argument was that the collector has talked to a third party about your case, albeit unknowingly. So that may be another case where I think that Reg F has done some good. It's given us some safe harbor as to what messages we can read. Now let's get into the meat of why do I need to know about the FDCPA? Am I covered by the FDCPA? The FDCPA regulates third-party debt collectors who collect debts on behalf of another. It defines debt collectors as those who regularly collect debt owed to others. It does not include original creditors collecting on their own debt. So again, if Mitch is going to sue his own client on his own behalf to collect that bill, he's not covered. If he's going to represent Mario and collect Mario's debt, he is covered. The other thing to know is that the FDCPA only applies to consumer transactions. Well, let's back up a minute. It says you use interstate commerce or mail in a business that has the principal purpose of collecting debts or who regularly collects debts owed to another. Note that is an or situation. It can be one or the other. We'll talk about it later in the materials, but there was a case where a very large debt purchasing company got sued, and they argued we are not collecting a debt owed to another. We're collecting a debt owed to ourselves. We bought the debt from Big Bank X. The court agreed with them and said you are not collecting debt owed to another. You're collecting your own debt, therefore it is not an FDCPA violation for whatever it was they allegedly did. Plaintiff's counsel did not argue that they are their business had the principal purpose of collecting debt because they were a debt buyer. That is all they did was collect debt, so clearly that's their principal purpose. So had consumer counsel argued that point, that case would have turned out very differently. There is case law that suggests if as little as 6% of your revenue comes from debt collection, you are in the business of principal purpose collecting debt owed to another. Obviously, 90+% of my revenue is collection, so I'm covered no matter what level you want to use. So, what is personal, family, or household debts? Credit card, medical bills, auto loans, mortgages, right? We can all think of a lot of things that are personal debt. If you are using the card, for example, a credit card, if you have a business card, right? Most of us who are small firm or solo practitioners probably have a business card and a personal card. The business card is business. It is not covered by the FDCPA. So if Big Bank X is suing you on your business card, it is not covered by the FDCPA. The key is that the debts are for personal consumption, not business, commercial, or agricultural needs. Some interesting things that are not covered by the FDCPA: parking tickets or tickets of any sort. So for example, you get a speeding ticket. Those will get turned over to me to collect. The Board of Commissioners in St. Joe County turns them over to us to collect. That is not covered by the FDCPA. I know we've got Tom from the city of South Bend in here. Some of his debt is covered by the FDCPA. If the city is suing you for an ambulance bill, that's covered by the FDCPA. It's a medical bill. If the city is suing you for a parking ticket or a citation issued for some other violation of their municipal code, it is likely not covered by the FDCPA. Regulation F, of course, clarifies it. To quote from the reg, it's debt related to any personal, family, or household purposes and not business or commercial purpose, including secured and unsecured debt incurred for personal, family, or household purposes, such as for credit card debt, medical debt, student loan, auto loan, accounts with utilities, telecommunications or cable companies, accounts with insurers, and accounts with realtors, and other extensions of consumer credit. That's clear as mud, thank you, because we have a circular definition that is related to personal, family, or household, and then we use those terms later in the definition. Note, eviction is the collection of debt. Rent is for a family or household purpose. I have seen a lot of attorneys file just for possession and not file for damages. There is a very strong argument that even though you are only filing for possession, that act is covered by the FDCPA. Because let's be honest, the primary thing your client wants when you file eviction, they want their back rent paid. That's the purpose of filing that lawsuit. The secondary purpose is if we can't get back rent paid, get the person out so I can rent it to somebody else. Our process, we ask our large landlord clients, based upon their lease, let's say the lease says rent is late after the 5th of the month. On the 6th of the month, they send us everybody that's late. We send out IVNs on all of those accounts. That starts our 30-day clock running. We cannot have the immediate possession hearing until after that 30-day period runs. Now we know we're going to send out 20 letters for this client, and we're going to get maybe 1 or 2 evictions out of that. The clients obviously are pushing us to get those immediate possession hearings as fast as possible for obvious reasons. If we wait until the 15th of the month or the 20th of the month to send that letter, we're now not going to get our IP hearing until the 20th of the next month, and so on. So we will wait 2 weeks or so after we send the letter. We will then file the eviction case, and we'll make sure the immediate possession hearing is set out past the deadline in the letter. Keeps our clients happy because we're getting things done faster. It's a bit more work on our end to send out that many more IVNs, but we have the process pretty well regulated. So I know there's probably some eviction attorneys in this room that are now having to think about that. If you want to discuss that in further detail, my contact information is on the front page of the materials. So let's talk about enforcement. As we discussed previously, the FDCPA has a private attorney general provision. So if you wrong the consumer somehow, you swear at them when they're on the phone with you or whatever it might be, they have the right to sue you directly. I know I have some other debt collection attorneys in the room, and I think I have some of their staff in the room. For the staff members, if you are the one that violates FDCPA, if you're on the phone with the consumer and you violate the FDCPA, I'll just say you swear at them. I know none of you are going to do that, but you swear at them. They can sue you personally. So make sure that you are following the FDCPA. Make sure you are following the procedures as set forth by your law firm, or you could be personally at risk. Now, they're going to go after your attorney because we have the deep pockets and the insurance. I have been sued. It happens in my industry. Unfortunately for me, it was right about the time I was trying to buy a house. You know, when you go through that mortgage loan application, they ask you if you're being sued. My answer was yes. We had a hard time getting the loan done, even though I had insurance to cover whatever the damages might be. The big kicker is always the attorney's fees. So a technical violation of the statute may result in $1,000 to the consumer. Consumer's counsel is going to be demanding $4,000 to $5,000 for their attorney's fees. $1,000 to the consumer is the drop in the bucket. Now, there have been some recent changes in the law that you would think, well, Brooks, those are fabulous for debt collectors. And on the surface, they are. First of all, the definition of a debt collector. Hines v. Jenkins in 1995 went up all the way to the Supreme Court, found that attorneys are covered by the Act. That was by a law firm that no longer exists in Maryville, Bowman, Hines, Basha, Vishen, whatever the rest of their name was. The court ruled that in Sheriff v. Geely in 2008, debt purchasers are not necessarily excluded from the definition of debt collectors. Prior to that, there had been kind of this idea that debt purchasers were exempt from the statute because they were not collecting debt of another, but go back to the principal purpose argument. Henson versus Santander was the case where we talk about a company not qualifying as a debt collector because it's a regular purchaser. That consumer attorney did not argue that Santander's principal purpose was collecting debt. Would they have prevailed on that? Who knows? We also have holdings that a non-judicial foreclosure, so those of you that foreclose in Michigan, it's a non-judicial process. Indiana is a judicial process. So Indiana foreclosure is covered by FDCPA. Michigan foreclosures, if you use their non-judicial foreclosure, it is not covered by the FDCPA. So as I say in my notes, the court did not address the issue of Santander was under the FDCPA for a primary purpose of collecting debts. Standing has become a huge issue in the FDCPA space. Back in 2016 in Spokane, which was not, I don't believe, a debt collection case, the court held that plaintiffs cannot allege a bare procedural violation of the statute and automatically get Article 3 standing. If you'll recall from con law in the first year of law school, Article 3 allows the court only to handle cases and controversies. If there are no damages, there's not a case or controversy. Subsequent to that, the court has ruled that plaintiffs lack concrete injury for standing because, in one case, because they had already received all their monthly pension benefits. I'm assuming that was an ERISA case, and there were no alleged financial losses. TransUnion versus Ramirez was an FDCPA case. The court found that class members whose credit reports were never disseminated to third parties did not suffer a concrete issue for standing, even if reporting mistakes existed in an internal file. So TransUnion had mistakes. Look, the rate of error on credit reports is pretty high, we all know that. But they could not get sued unless you could prove that the credit report was somehow disseminated and you somehow suffered actual damages. In a case that I'm not going to try to pronounce from 2021, the court held that the request for only nominal damages can satisfy Article 3 if a violation occurred. After Spokane, the Seventh Circuit has consistently weighed in on this issue. They have been very, very in favor of the creditor side in determining what standing is. So you cannot just invoke federal jurisdiction, you have to suffer an injury in fact. That's fairly traceable to the defendant's conduct and is redressable by a court decision. So what that means is these mere procedural violations are not going to result in FDCPA liability. For example, one of the theories that people were using for a very long time is if you had a category in your letter or in your lawsuit that had a zero. For example, you break down principal, interest, other fees, etc. When you say interest is zero, the theory was you're implying that interest could accrue, even if it's a case where interest is not accruing. So putting that zero in was false, deceptive, and misleading. The courts have said, yeah, but what injury did you suffer? What did you do as a result of that alleged misleading information? If your answer was nothing, I went to my attorney and filed an FDCPA lawsuit, you've suffered no damages. Therefore, your case is going to be dismissed. What we are seeing is people now filing these FDCPA cases in state court. State court has a different understanding of standing than federal court. So a mere procedural violation, or what we call an informational violation, may have standing in state court. Creditors' counsel is removing those to federal court and then actually arguing that there is standing in federal court because the federal court then finds that there were no damages and therefore there is no standing. So you now have a federal order saying there were no damages. That goes a long way in state court. I anticipate federal courts becoming unhappy with that. Why are you removing something to my court when you know darn well there's no standing? We may start to see creditors' counsel stop doing that, and I frankly would not urge counsel to do that. So the key is that there has to be a tangible, concrete injury that occurs or is imminent rather than just a procedural statutory violation. Standing also has to be established for each class member. It's a class action suit, not just the named plaintiff. However, nominal damages may provide that redressability. So the advantage is that these suits, in theory, should become less because debtors' counsel knows they have no standing. The practical reality is you get shaken down. You'll get a letter or a proposed lawsuit saying you had this procedural violation. We're going to file it in state court, so on and so forth. You can usually settle those cases for $4,000 to $5,000, $6,000. If you hire an attorney to fight it, you're going to pay that in legal fees in the first month. So a lot of times those cases get settled. If you run into that situation, you still need to turn that case into your insurance company. So what we do in that situation is we turn it into our insurance company, we call the adjuster and say, look, we want to try to settle it for less than our deductible. The insurance company will say, great, here's the form of release we want you to use. If you settle it for less than your deductible, just send us a copy of the release. If you can't get it settled, then we'll hire your counsel. So if you can settle it for less than your deductible, you're ahead of the game. You'll feel like you're shaken down because that's probably really, in my opinion, what happened. So some of the new case law that's coming out, or the new theories, debtors' counsel is having to get creative. They have to attach their theory of liability to something that exists in the common law. For example, invasion of privacy. If you can improve invasion of privacy, you now have damages that will confer Article 3 standing. Large volume collection agencies or law firms will use a letter vendor. Letter vendor is an outside source. You give them a form letter. Here's our form IVN, our form, late payment letter, whatever all you're going to send out. And then you can literally just send them a spreadsheet that says in field 1, put this, and field 2, put that. They'll generate the letter, put it in an envelope for you, and mail it out. Hunstein sued, saying, well, that's invasion of privacy because you've now told this third party about my bill. Those letter vendors work on high volume. Their machines can literally print and stuff several 100,000 envelopes a day. Ain't nobody looking at those. No human can look at them fast enough. They may pull a certain amount out here and there for quality control, but that's about it. So the trial court in Hunstein, which was in the 11th Circuit, basically said that is a violation, it's invasion of privacy. The circuit court said the same thing. So now you're upending the entire industry, right? These large volume actors are going to have to figure out how to bring their mail in-house. In banc, the 11th Circuit reheard it, and at least in the 11th Circuit, they said this theory doesn't fly. That is not an invasion of privacy because of the mechanical nature of that process. As I was preparing my materials, the 7th Circuit was up in the air on that issue. There were some cases at the trial court level that said, yes, that's a viable theory, and some that did not. I had to update my materials because on October 23rd, 2023, the 7th Circuit came down and said they agree with Hunstein too, that this is not a violation of the FDCPA. So you can use a letter vendor if the volume of your practice warrants that. That's simply a cost-benefit determination of business decision at this point. So to talk about some of the other violations, and this is kind of going off the materials since I'm a little bit ahead of schedule here. Some of the things that get sued over: a windowed envelope. I did not know this, but the little window that the address shows through is called a glycine window. It's glycine plastic is what the covering is. There were lawsuits because something other than the address showed through the glycine. we've all seen QR codes, right? A lot of large collection agencies or debt collectors will have a QR code. Hey, you want to make a payment? Scan this QR code. It'll take you right where you need to go to make a payment. That QR code appeared through the window. Well, that's now somehow telling somebody that you owe a debt because they could have scanned the QR code and found out it went to Chrysler and Associates website. The zero theory that we have talked about, that is one that baffles my mind. You're using a form letter, and in fact now the Reg F letter says you've got to include those categories. So I think these are the kind of things that at least the Seventh Circuit was seeing as just petty, and that's why they've really come down on the scanning issue. So the FDCPA can impose liability on the debt collector. Attorneys certainly qualify as that if you're collecting consumer debt. It's a highly technical statute. This hour-long presentation does not in any way, shape, or form make you qualified to say, hey, I know everything there is to know about the FDCPA. As I said, I spend hours a week learning more about it, and I will never tell you that I know everything there is to know about it. For example, the district court in Oregon, within the last couple of days, issued an opinion. The debt collection law firm hired a process server to file the lawsuit and serve it. So I think it was a situation where they had to physically paper file it with the clerk, and they didn't have an office there, so they just had their process server do it. The process server filed it, but served a copy on the consumer that did not have the cause number on the complaint. The consumer sued, saying that's deceptive, I didn't know what was going on, it took me time, effort, and energy to find the cause number and find out that I was really being sued. District Court in Oregon said that theory doesn't fly. I think the reason they said that theory didn't fly is because the consumer was served with the lawsuit, let's just say on March 10th. They filed their federal lawsuit on March 11th. Right? It was a gotcha. They had probably already been in contact with a consumer attorney about something else and went down that road. Northern District of Alabama recently had to deal with a defendant or a consumer who sent plaintiff's counsel a letter saying, I do not owe this debt, do not send me any more mail. If you want to contact me via email or text, and provided that information. Plaintiff's counsel turns around and sends the validation that's required. The District Court of Alabama said that theory flies because he was not disputing the validity of the debt. He just said, I'm not going to pay it. He didn't say he didn't owe it. He said, I'm not going to pay it. I think the other problem is for the attorney, that was some 4 years after the validation period had expired. Validation period only lasts 30 days from the receipt of the initial letter. They had no obligation to send anything to this consumer. In our office, we would mark that up as what we call a cease and desist contact, and the only thing that would be sent out on that case would be court pleadings. The 10th Circuit recently ruled on convenience fees. We have an outside vendor that processes our credit cards for us. We maintain a website. You can go to our website. When you click make a payment, it actually pops you out to the third-party vendor to process your credit card. As those of you that accept credit cards know, there is a couple of point fee on all of that. There's so many cents when they enter the card and so much percentage of the transaction. Collection agencies are trying to charge those fees back to the consumer. 10th Circuit said that is okay so long as you have some method that the consumer can pay that does not incur a convenience fee. So you can say there's going to be an X percentage convenience fee on the credit card. If you want to pay for free, mail us a check. The other kicker is you cannot make a profit off of that convenience fee. The pro tip would be just let your credit card processor deal with that. Let them charge the convenience fee because they will charge exactly what that fee is to the penny. You're taking none of that money. If you're just flat out saying there's a $5 convenience fee to use your credit card, and that happens to be more than the actual fee you're paying, you're now making a profit off of that fee, and you will get in trouble for that. Questions? Oh, come on, it couldn't have been that good that there's no questions.
In an eviction situation where your client has told you flat out they don't care about getting back rent paid, they just want the person out, that would jump out of the FDCPA or still be in it?
I think there's an argument that it is within the FDCPA because the purpose of, you can argue that the purpose of filing that eviction is to collect the rent, even though you are not pursuing damages. You might have an argument if the lease is over, like if you're beyond the term of the lease and it's a 30-day notice rather than a 10-day notice that your client sent. I wouldn't be comfortable being the one to find out the answer to that. That corner.
Do you see any cases or guidance on situations where what the plaintiff alleges is clearly a commercial or business that a debtor is a sole proprietor or signed a personal guarantee and is making some sort of claim that other the finances are so intertwined that this is my personal situation?
You have to look at the underlying purpose of the loan. So there was a case, and I can't give you a site, the original underlying mortgage was for the primary residence. The person bought it as their primary residence. They later moved out and did Airbnb or whatever with it. That was still a consumer transaction because the original underlying transaction. So if you sign, if you're a sole proprietor or a single member LLC, and you sign a lease for your office space in the name of the LLC, and then you have to give a personal guarantee, that's still a business purpose. You're not living there. That's not a household purpose. So you have to look at the underlying transaction and make that assertion. And it's at the time the transaction is entered into. So if you bought the house for purposes of making it an Airbnb and later moved into it, there's a good argument that that's not under FDCPA because the original purpose was a business transaction.
So is a letter from the attorney for a landlord on a commercial lease, is the letter from that attorney saying you're behind 3 months, you owe X dollars, or the client will have to bring eviction? Is that governed, or is that exempt?
No, it's because it's a commercial lease. So if it's a business-to-business transaction, it's simply not covered by the FDCPA. Or even if your client, that was the only commercial space they owned, and didn't do anything else in that space, the underlying purpose of that lease is commercial by the tenant.
Brooks, what about if probably commercial debt put on there this communications from debt lenders?
You can't pull yourself into the FDCPA.
That's my question.
Right, so if you send out the Reg F letter or put the this is an attempt to collect the debt language on something that is clearly not FDCPA, you're not pulling yourself into that transaction. Again, we collect things that are not FDCPA. Board of Commissioners for the speeding tickets, some stuff for various municipalities. We will put the this is attempt to collect the debt language on stuff just because it's reflexive. It does not pull that particular transaction into the FDCPA. Anyone else?
How have state courts been handling the ones you were talking about where they wouldn't have standing in federal court, but so they've been filing them in state courts?
Well, the state courts will, depending on the facts of the case, they'll find standing. Then you're arguing over whether or not you have statutory damages. So I think that from the debtor's or the consumer's attorney's perspective, that is a good strategy. We have seen, so I get an email once a week from a service that I use of every consumer federal case, FDCPA, Fair Credit Reporting, Telephone Consumer Privacy Act, just a listing of cases filed. And I will go look at the ones filed in Indiana. Federal case FDCPA litigation in Indiana has fallen off. It does not exist. The ones you see are now Fair Credit Reporting Act issues. Because there's not as much argument about standing there as there has been in the FDCPA space. I do not have any vendor right now that is tracking state-level FDCPA claims.
If you're dealing with an eviction, it's not for non-payment of rent. Perhaps it's illegal activity on the property, or something like that. Are you still on these?
I think you have a good argument that you're not within the FDCPA because your purpose is not collecting rent. It is to secure compliance with another portion of the lease. So if they're committing waste or they're smoking marijuana in the apartment or whatever it might be. And we will file emergency evictions without sending the FDCPA letter if it is for non-rent related issues. Anything else? We got to fill 5 more minutes. We want to get our credit.
If you're comfortable, tell us how your lawsuit came out when you were sued, and tell us if you got the house.
So the house, thankfully we were getting our loan through Teachers Credit Union. I clerked at TCU in law school, so I knew in-house counsel. So I called her and said, now, what can we do? She's like, wait a minute, there's a limit. So there's a statutory limit in the FDCPA for damages. They cannot exceed, it's either 1 or 2% of your net worth or $500,000, whichever is less. So Val said, wait a minute, I know there's a limit. Can you send me the statute showing the limit and then send me the declaration page of your insurance so you have insurance greater than the limit? Because we all knew, it was the first house I bought, we all knew 2% of my net worth wasn't no $500,000. So she knew I had more than $500,000. They wrote the loan and they had to keep it in their portfolio because it was non-conforming. They couldn't sell it. We settled the case for sums I cannot disclose. So the other thing we get a lot of, and this is just kind of some war stories, we record 100% of our phone calls. When we first started doing that, I was against it. I didn't want to be big brother to my staff. It has paid enormous dividends. We got a demand letter from Consumer Counsel saying that we had threatened to garnish somebody's Social Security check, which of course you can't do. We go back and listen to the phone call. The lady had a hearing the next day. We had filed a pro-sup against her bank account. Her bank account was frozen, and she told us on the phone, my only income is Social Security, what do I do? We told her, your hearing's tomorrow, whatever time it was, bring proof of that with you, and we will vacate the freeze on the bank account. So we shipped that phone call off to Consumers Counsel and got a very nice letter back saying he was no longer going to pursue the case. It also pays dividends in front of judges. We had somebody that we were garnishing. Her husband called, because apparently he was the one that was supposed to be paying the monthly payment to us and didn't do it, which resulted in the garnishment. And he was just swearing. I mean, F word is every other word out of his mouth. So of course we hang up on him. Wife calls back. She was relatively nice, but we wouldn't give her any relief because of, well, her husband. She files a petition with the court asking the court to reduce the garnishment. And I tell the court, well, you know, the husband called and this is how he acted and so forth. And the lady says, well, my husband would never do that, Your Honor. I don't think that really happened. Well, Judge, you want to hear the call? I've got it on my phone. We can play it. You're going to have to bleep about every other word. And the lady finally, head down, no, we don't need to play it. So, again, conduct yourself as though the call is being recorded and it's going to be played for the judge.
I'm not calling you.
You have my cell number, right?
So, what do you do technologically? How do you handle recording all phone calls? Do you do that cloud-based, or is there?
Yeah, we have a voice over IP cloud-based phone system, and they take care of it.
Do you just pay for all that storage? I mean, probably a lot of data.
They will only keep it for like 30 days maybe, and we have client requirements to keep it longer than that, so we're able to download it to our server. Anybody else? Well, in the words of the House of Representatives, I yield back the balance of my time. 3 minutes.